base walls with white planes. And I had a partial scholarship, so that was part of why. That was a big environmental school. I liked it, but my wife wanted to move back to Virginia. She just started thinking about, well, we're gonna have kids and we want our grandparents to something. So we came back, so I started looking at transport, and that's how I saw it. You know, comparing Mason, it was a good deal. But I didn't go where you are, which is not real.
I'm from Kansas.
Oh, yeah.
Went to John Randall today, or yesterday.
Yeah.
I see they pastoral homes.
Oh, good. I haven't been there, so
I
I
think we don't have to worry about that now.
Mr. Chairman, I have
Dean,
6:30,
I think we need to,
probably.
All right, we'll go ahead and call tonight's planning commission meeting to order. Mr. Johnson, if you please call the roll.
Yes, sir. Mr. Matt Seal,
Here.
Mr. Steve Donahue,
Here.
Mr. Kevin Meadows, Mr. Hubert Allen,
Here.
Mr. Steve Rosen,
Yes.
Mr. Harry Donahue,
Here.
Mr. William Flippen.
Here. Okay, and do we have a motion for the
Mr.
approval?
Chairman, I move that we adopt agenda as amended.
Second?
Second.
Sorry. Mr. Matt Seal,
Yes.
Mr. Steve Donahue,
Yes.
Mr. Hubert Allen,
Yes.
Mr. Steve Rosen,
Yes.
Mr. Harry Donahue,
yes,
and Mr. William Flippen.
Yes. And we have some requests to set public hearing.
We do not have any requests to set this evening, sir.
Okay. We'll move on to public hearings. We'll now open the public hearing. Is that correct?
Yes, sir.
Okay,
And I can start the staff report if you'd like.
please.
Okay, so the first public hearing I have for you this evening is for Code Amendment 2404 for the Board of Zoning Ordinance Appeals. This is a request to amend Chapter 74 and revise the existing language to ensure continued compliance with statutory regulations. Virginia code that regulates the BZA were updated in 2022, requiring an update of our local ordinance to ensure continued compliance. Staff has drafted and the county attorney has reviewed the draft that is coming before you this evening. This is the same text that we had looked at probably late last year or early this year. We just not had, we didn't have the time to make it to the public hearing with different scheduling changes, employee conflicts, that sort of thing. So before you this evening in your packet and on the presentation tonight, we do see the marked up version of the ordinance, which again just provides for compliance with the state code. And Mr. Chairman, I'll just make note at 6:32, Mr. Meadows arrived. That's okay. Thank you. So for 74-2 regarding definitions, we're updating the definition of the variance to include the height and also to change the language where previously it had to result in unnecessary or unreasonable hardship to the property owner. And the new state code just references unreasonable restriction to utilization of the property. For 74-821 appointment, the first sentence is actually being stricken as it is not in compliance with the state code, where it says that the board shall annually choose its own chairman and vice chairman who shall act in the absence of the chairman. For powers and duties, we've got this whole section here. So what happened was state code moved some things around, so we have big sections of our code that are being taken out completely, and I just replaced that with exactly what was included in the state code. Here you can see where, again, powers and duties, we added the previous paragraph, and we're taking out this entire paragraph. It's also removing A, B, and C under 74-821. I'm sorry, A and B and part of item C. It is adding to grant upon appeal or original application in specific cases, provided that the burden of proof shall be on the applicant for a variance to prove by preponderance of the evidence that his application meets the standards for the variance. The application shall be granted if the evidence shows that the strict application of the terms of the chapter would unreasonably restrict the utilization of the property, or that by granting of the variance would alleviate a hardship due to either physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, which was July 9, 1990, or alleviate a hardship by granting reasonable modification to a property or improvement thereon requested by or on behalf of a person with disability. We are adding in additional powers and duties for the BZA. It says the property interest for which variance is being requested was acquired in good faith and hardship was not created by the applicant. The variance will not be a substantial detriment to the adjacent property owners. The condition or situation of the property concerned is not so general in nature as to require a code amendment, and that the granting of the variance does not result in a use that is not otherwise permitted in the zoning district. Lastly, the relief sought by the applicant for the variance is not available through a conditional use or rezoning. No variance shall be considered instead of authorized. We do have that one change there. And we're adding in that the property upon which the variance has been granted shall be treated as conforming with the regulations of the chapter. However, the structure permitted by the variance may not be expanded unless it meets the current zoning requirements. We're adding in the very last sentence here, the zoning violation or written order shall include the applicable appeal fee and a reference to where additional information may be obtained regarding the filing of an appeal. The appeal period shall not commence until the statement is given and the zoning administrator's written order is sent by registered or certified mail to or posted at the last known address or usual place of abode of the property owner or agent, if any. And the owner's actual notice of such notice of zoning violation or written order or active participation in the appeal hearing shall waive the owner's right to challenge the validity of the board's decision due to the failure of the owner to receive the notice of violation or the written order. Appeals shall be submitted to the Board of Zoning Appeals in the care of the zoning administrator, and a second copy shall be mailed to the individual official, department, or agency concerned, if any. Completed appeal application packets shall include the fee assessed by the Board of Zoning Appeals in section 2.3 of the county's ordinance. And any person, going back, this is a change to section 74-827, which is a certiorari to review the decision of the board. So if the Board of Zoning Appeals denies a variance, the applicant has the ability to appeal that by a writ of certiorari through the circuit court. Any person or persons jointly or severally aggrieved by any decision of the Board of Zoning Appeals, or any aggrieved taxpayer, or any officer, department, or board of the Bureau may file with the clerk of the circuit court a petition that shall be styled NRE, date decision of the Board of Zoning Appeals of Cumberland County. Upon presentation of such position, the court shall allow a writ of certiorari to review the decision of the Board of Zoning Appeals and shall prescribe a time in which a return must be made and served upon the Secretary of the Board of Zoning Appeals, which shall be not less than 10 days and may be extended by the court. Once the writ of certiorari is served, the Board of Zoning Appeals shall have 21 days as ordered or as ordered by the court to respond. Any review of a decision of the Board of Zoning Appeals shall not be considered an action against the board, and the board shall not be a party to the proceedings. However, the board shall participate in the proceedings to the extent required by the Code of Virginia. The county, the landowner, and the applicant before the Board of Zoning Appeals shall be necessary parties to the proceedings in the circuit court. The court may permit intervention by any other person or persons jointly or severally aggrieved by any decision of the Board of Zoning Appeals. The circuit court may reverse or affirm wholly or partly, or may modify the decision brought up for review by the BZA. In the case of an appeal by a person of any decision of the Board of Zoning Appeals that denied or granted an application for a variance, the decision of the BZA shall be presumed to be correct. The petitioner may rebut that presumption by providing a preponderance of the evidence, including the record before the Board of Zoning Appeals, that the board has erred in its decision. Costs shall not be allowed to go against the Board of Zoning Appeals unless it shall appear to the court that it acted in bad faith or with malice. In the event that the decision of the board is affirmed and the court finds that the appeal was frivolous, the court may order the person or persons who requested the issuance of the writ of certiorari to pay the court costs. That is the long and short of that code amendment. Again, this is just an update to our local ordinance because state code changed, which then requires an update for us.
I got a question,
Yes, sir.
and I apologize to bring this up again. I asked it last time, but it's still, the language is still very confusing to me, and I'd like to know what it actually means in reality. Under section 74.824, appeal to the board, last paragraph of A, the owner's actual notice of such notice of zoning violation or written order or active participation in the appeal hearing shall waive the owner's right. So, okay, I understand participation in the appeal. In other words, if they show up and they participate in the appeal, obviously that waives your right. The owner's actual notice of such notice, what does that mean?
So they're them being notified of the notice or the notice of zoning violation. So their actual notification of the violation or participation in the appeal.
Right, so what I'm trying to figure out is it possible for someone to get these notices and not know about it?
Yes, and the only instance that I can think of at the moment is where I've mailed public hearing notices. People get the mail, they set it on the counter, and then they don't open it or they don't read it. So they've received it, but they don't maybe know that they received it because they haven't read it yet. That's actually happened with a conditional use permit or two, where they came to the public hearing and said, you know, I didn't get the notice until today. And then they said, well, I got it in the mail a couple weeks ago, but I didn't open it until today.
So, and those were sent by certified registered mail.
No, sir. So the code allows us now to send them by regular mail, by first-class mail, but I certify and my signature is notarized on a document that states that I mailed them out on certain dates.
You're certified.
Yeah.
So, I don't like this. Is there anything we can do to make it so that,
Clarify that?
well, yeah,
Sentence?
clarify it and make it so that it can't go unnoticed?
How do you guarantee that?
Well, I mean, there,
I'm sending out the notice, is
No.
whether or not they read it,
right, right.
so I'm not sure how
So
we
do you need
how we do that.
maybe a guarantee that they received it? Whether they read it or not, how do we know? How does anybody know? We can guarantee if they have to, you know, if it's certified they have to sign that they received it, then they've got it. They can't say they didn't get it. Whether they read it or not is their choice.
Sheriff's deputies.
Yeah, I mean,
And then we have to increase the cost of
Right.
the fees associated with
Yeah.
Well,
it.
that's okay. I don't think it should cost the county any more money.
I mean, this language is taken from the state ordinance, state code, so I mean, it's,
I understand that. That doesn't mean that necessarily that it's right or good. It
it
just,
may not, but I mean,
But you
what
have
we're
to
trying to
say
do is get the BCA in compliance with the state code, which we aren't at the moment.
yes, I understand that too. And Yeah.
You're trying to eliminate,
I'm trying to eliminate a property owner, not knowing about it. And unable to participate because they don't know about it.
Can I offer a little bit of clarification?
Yes.
So when it comes to a notice of zoning violation, that is kind of the last step in my code enforcement process. So my first step is, receiving anonymous requests. However I get the information, I schedule a time to go out to the property to verify whether there is or is not an actual code violation. From my perspective, code enforcement is about compliance, not going to court. I would rather fix the issue than have to issue a notice of violation and then have to go to court. So not yet once have I had to issue a notice of violation. So the way that the process works currently, the property owner has to know about it because I have to contact them to verify whether or not there is an actual notice or an actual code violation on the property. So they would know that there's a violation prior to an issuance of an actual notice of violation.
do you explain to them, when we're talking about that the next step, if they don't correct the violation, is that they'll be receiving
An official notice of
yeah,
violation?
official notice?
Yes.
They know that, so
Yes.
that's the way it is now.
This section is under appeals to board.
I'm pulling it up from the state code as we speak, just to make sure, of course. it doesn't matter. I'll be faster if I do this.
And if that goes out certified, who can sign for that? Can the spouse sign?
Anybody can sign for it.
And where was it, the residence or the address? Anybody over 18?
So I'm just trying to think of a situation here. So they get the notice, set it on the table, forget about it for 35 days, and they can't appeal.
Well, that's their problem.
Is that, and I understand that, correct?
Days. What if it was a bill?
But one thing we've got to realize too, the person who's getting the notice of the BZA hearing is the actual applicant who is appealing the decision of the zoning administrator to the BZA. It's not going to a surrounding property owner or anything. The person who has violated it is either the property owner or their renter. And in those instances, it will come before the property owner who wants to come before this BZA. I mean, I'd set on the BZA. We've had one case since I was born. The property owner knew the situation. He appeared, as a matter of fact, he talked to BZA members before the actual hearing. And we all, at least 2-3 of us visited the site. There was no way from his initial communications with Ms. Johnson through the entire process that he wasn't aware of what was going on. There's no way anybody with any average intelligence would not realize what was going on and what the course of action that had to take.
So what is this paragraph trying to solve?
To have somebody, if they show up, to try to say that they weren't notified, because state code requires me to notify them of the notice of violation and the appeals. So if they say they didn't get notice of the appeal or notice of the notice of violation, then that could say, that I didn't do my job as required by state code, which would give them leeway in the appeal.
In our BZA packet for this hearing, Ms. Johnson had their notice of violation in the packet. Their applicant who was appealing her decision had in paperwork he presented us the notice of violation from her too. So there's no question he had received it. And
Right, I mean, I can understand the clause, active participation. I mean, obviously, if they show up and they're participating, they got the notice.
Right.
I mean, that, what I don't understand is the actual notice counting as a notice.
I mean, that's legally what I'm required to do. I'm required to give them notification of the hearing. So I send them a notification. And like, I think for this one, it says that it has to be by registered or certified mail to the last known address or usual place of abode of the property owner or the resident. So let's say if I posted it at the last known address or usual place of abode, they can say, well, I didn't get it. I didn't know about it, even if I posted it. That's what we're trying to avoid. Now, if it's sent certified, that's one thing. If I do return receipt, then that requires a signature. But again, anybody can sign for it. So again, even if I do follow the state code and send it as certified mail, return receipt requested, they can still say that they didn't get the notice.
yeah, I think you can, on certified mail, I believe you can say that the addressee has to sign for it.
Right.
Not just anybody.
Right. Well, two, they can, even if they get notice that there is a certified letter at the post office, they can just not go pick it up.
Yeah. Yeah.
So again, we've done what we're required to do by state code to notify them. And if they chose not to pick up the certified letter, or if they forgot that the letter was sitting on the counter on the island for 2 weeks, we've done what we're required to do by code.
Yeah. What's the difference between a notice or a written order? What's a written order?
So a written order, I guess, would be for an appeal, not for a notice of violation. A written order could be
Ordering them to
anything.
go to something, or commanding them, or dragging them out of their house and breaking down the door and saying, hey, you have to be at this appeal hearing right now, we're gonna hold you to your appeal hearing. The language limiting the burden of the government to have to notify the person whether they actually understand the notice or not, in the actual notice language.
The written order would be entered by the BZA, or if it was appealed to the circuit court, the circuit judge. Notice would be given by the matters under administration, the one who designates.
So a written order is like a judgment or something, right? I mean,
It could be. Any written order from my department regarding code, whether it's an actual notice of violation, or it could be, you put up a building and didn't get a zoning permit. You need to come in and get a zoning permit for the structure, you need to follow the code. That could be considered a written order.
yeah, I mean, I see that it goes out of the way to protect the county. There's not a lot of protection for the property owner.
I mean, by this point, if we're going to court, there's been open dialogue, there's been communication, there's been site visits, there has been phone calls, emails. So I don't see how anyone could say that they didn't know.
It protects the landowner or the person, because they can't try to appeal something to run for government appeals. And through their appeal, and now the government is giving now's the time we're gonna hear it, they have to do it with a written notice. Whether they actually receive the written notice or not, in the actual notice, notification part, that's on the burden of the person that's appealing to be actually notified, which they've already actively participated in, so there's a lower burden. So it's going to have to post a notice or receipt to certify them.
You know, I
It
feel,
goes both ways.
I'm sorry.
Sorry.
I feel that it's less our responsibility to protect the landowner than it is to be fair to the landowner. And if we're being fair to the landowner, then I'm fine with that. If they want to say they didn't know about it, and we know they did, to me, that's their problem. But I do want to be fair to them, but I don't think it's our responsibility to protect them.
If it goes to a BZA, they appeal it to the BZA, they know that there's a hearing scheduled. They know when it is. If they elect not to show up at a BZA hearing, BZA rules against them. Kelly has done everything he could to be fair to them. And I don't know what you can't force them in because you can't, BZA does not have subpoena powers to order them to appear before.
So I've got the state code up here on the TVs, and I've highlighted that section of the state code. The owner's actual notice of such notice of zoning violation or written order or active participation in the appeal hearing shall waive the owner's right to challenge the validity of the board's decision due to failure of the owner to receive the notice of zoning violation or written order. So that's the owner's actual notice of such notice. That's exactly from state code is what I put in the ordinance.
So you've done everything a prudent person could do to notify by state code.
So that last sentence, though, that you don't have in here, that's in the state code, helps make it more clear.
For jurisdictions that impose civil penalties.
No, you added something when you read that, it's not in here.
The owner's actual notice of such notice of zoning violation or written order or active participation in the appeal hearing shall waive the owner's right to challenge the validity of the board's decision.
It is in here, all right, but challenge the validity of the board's decision.
Correct.
Right, okay. Due to failure to receive the notice. Okay. All right, we can move on. I mean, that's, you know, I don't know how to solve it. I still don't really like it, but I don't know what to do about it, so.
Are there any other questions about the Code Amendment 2404 Board of Zoning Appeals?
Back on section 7482(1), it ends with 8. Is that just a misprint or
Which
person
one?
with disabilities 8? Page 6.
Page 6, thank you.
And, although that's a continuation, so you got A, B, C, D, so it's a continuation of that paragraph. And the property and consideration.
Do we have a motion?
I'm sorry, Mr. Chairman. Yes, sir. So we did open the public hearing. We don't have anybody signed up to speak, so we can now close.
Okay, so we'll close the public hearing.
Mr. Chairman, I move to adoption of CA 24-04 Board of Zoning Appeals Ordinance Amendment, and that it be sent to our Board of Supervisors with a recommendation it be adopted.
And a second?
Second.
Matt Seal,
Yes.
Steve Donahue,
Yes.
Kevin Meadows,
Yes.
Hubert Allen,
Yes.
Steve Rosen,
Yes.
Harry Donahue,
Yes.
William Flipp.
Yes.
Okay. Moving on.
All right, thank you. Next public hearing we have this evening is for REZ 2501 Falco Investments. The property owner, I'm sorry, it should be leased to own, is that correct?
Under contract.
Owner contract to purchase, okay, sorry. Falco Investments LLC. The applicant is Retson Companies, and they're requesting a rezone from R2 to B1. The property is 2.928 acres at the corner of Glenham Road and Anderson Highway. Current land use is agricultural, and there is one existing structure on the property. It's a 12 by 30 residential shed. Here we show the vicinity map of the proposed location. Here is the zoning map, which shows the property outlined in purple. The adjoining properties are zoned residential, B1 business right across the street, M1 industrial to the northeast, and then we do have a industrial with a conditional use permit to the southwest, and that is where the former County Line Auto is located. Here we have for you the 2023 comprehensive plan map. And then I've zoomed in here a little bit closer. This property does appear to be either in or just outside of the Clinton Rural Crossroads as shown in our 2023 comprehensive plan. However, we have not yet gone into the small area plan, so we can't determine exactly if this property is within or just outside of that rural crossroads area. Here we have the aerial map of the property, and again, this photo was taken in 2022. We have the current survey for the property, which was from July 24th of 2006. And again, the applicant is requesting to rezone the parcel to build a 10,000 square foot Dollar General Market retail store. The initial site plan showed the store facing Anderson Highway. However, after communication with VDOT and working through site distance requirements, the site plan had to be revised to show the entrance to that parcel moving farther down Route 606 Glenham Road. The change in the entrance has also changed the situation of the building on the property, where the front facade of the building will not face Route 60. Parking spaces, section 74-988 of the ordinance requires one parking space for each 250 square feet of retail floor space of the building. It has, the proposed building is 8,572 square feet of retail space, which would require 35 parking spaces, 2 of which will be considered accessible parking spaces. The applicant is requesting a waiver of the parking spot requirement to reduce the number of required spaces from 35 to 30, to redesign the site so that the front of the building can face Route 60 Anderson Highway. The applicant did submit a letter from the architecture and engineering manager of Dollar General stating that a reduced number of parking spaces requested of 30 will exceed the number of spaces needed during the highest peak hours of sales. And that letter is included in your packet for this evening as well. So I went back and I looked at all of the Dollar General, Family Dollar stores that we have in the county. The building square footage, the retail square footage, the number of parking spaces that the county required, and then the number that they actually installed. For the one right up the road here, DG Market on Anderson Highway, it required 50 spaces and they did install all 50. The one on Cumberland Road by Midway Market required 29 spaces and they installed 32. The newest Family Dollar, Dollar Tree up the road required 36 parking spaces and they installed 44. With the exception of the Dollar General down here on 60, I would say that I've never seen the parking lots full at any of the other locations at one specific time. However, the one down the road here, with it being centrally located and being the DG Market that we have in the county, I think plays a role in the fact that they do get busier than the other sites. And I would say that it would be up to the planning commission to make the recommendation and the board of supervisors to decide how important the front facade of the building is facing Route 60, because that's what we would be giving up, would be some parking spaces in order to make that work. Initially, when the site plan was submitted to me, I was fine, everything looked like it would work, and then after the VDOT review, when they did come back and have to move the entrance, I did discuss with the applicants the possibility of keeping the southern entrance to the property and still facing the building on Route 60. However, with the larger trucks coming in, that turn would make it very difficult, the way that the building would be situated, to have it also face Route 60 with keeping the required number of parking spaces and having that entrance move south along Glenna Road. So they are again asking for a waiver for that request. Additionally, the applicants offered voluntary proffers for the rezoning of this parcel. They have excluded and plan to restrict illegal and nuisance uses, including any unlawful purpose for which it would constitute a legal nuisance to an adjoining property owner or occupant, a discotheque, dance hall, or nightclub, massage parlor, funeral parlor, bingo parlor, any assembly, manufacturing, distilling, refining, smelting, or mining operation, any secondhand store or liquidation outlet, mobile home park, trailer court, junkyard, recycling facility, or stockyard, any dumping, disposing, incinerating, or reduction of garbage, exclusive of the garbage compactors located for the facility itself, no dry cleaners performing on-site cleaning services, no automobile, truck, trailer, or RV sales, leasing, or storage, the establishment selling or exhibiting paraphernalia for use with illicit drugs, and establishment selling or exhibiting material or devices which are adjudicated to be pornographic by a court of competent jurisdiction, an adult bookstore, an adult video store, or an adult movie theater. They've also proffered to exclude any bar or tavern. However, a bar with a restaurant shall be permitted, a bar within a restaurant, a pool hall, billiard hall, gun range, shooting gallery, or amusement or video arcades, and facilities for the use of treating addiction. For the planning implications, according to the comprehensive plan for 2023, the proposed use and rezoning does achieve some of the goals of the 2023 comprehensive plan, including goal number 8, to create a diverse economic development opportunity. Objective 8.2 states that the county will encourage the development of service and retail business to meet the needs of the community. And objective 8.4 to facilitate the conditions needed for new and small businesses, particularly in village centers. For the uses that are permitted in the B1 zoning district, here is a list of the uses that will be permitted, excluding those proffered restrictions by the applicant. They would include antique shops, bakes, bakeries, a car wash, convenience store, farm supply store, general store, a laundromat, office buildings, printing presses, professional offices, wear and apparel store, a kennel, a commercial kennel could potentially be a future use for that parcel. For public engagement, notice of the hearing was published in the Farmville Herald on May 7th and 14th. Adjoining property owners were sent notice for the hearing via first-class mail on April 23rd. And this parcel is not located in the public utility services area and will require private water and sewer systems. Of course, the application for the traffic impact determination was submitted to VDOT for comment. They provided that the revised access location does comply with the department's management standards, access management standards, and the anticipated site-generated traffic does not trigger the need for a comprehensive traffic impact analysis. However, that will be required at the time of the site plan review to evaluate the need for a turn lane or a taper. And then lastly, I have received no comment for or against this request. So I will be happy to take any questions. If the commission does not have any questions for me, the applicant is here, and they do have a presentation in the PowerPoint for you guys to see.
I have a question that doesn't really, to me, concern approving or not approving the project, but do we have any idea, or has there ever been any studies done that if a business like this comes in, does it attract other businesses to the area? Could we expect that there would be businesses because there's Dollar General, I mean, we know that Dollar General's going to do some business, so
Right.
that's going to bring other businesses in, hopefully?
I'm hopeful that is the case, especially since the 2023 comprehensive plan did designate this general area as the Clinton Rural Crossroads. And we are trying to entice other businesses and other development in these rural crossroads and village centers. As far as specific studies, I'm not aware of any. The applicant may be able to provide some additional information.
I'm sure that the site location would be much more attractive with them there than without them there.
Yes.
No question about that.
Mhm.
Steve?
Yes, could you, I tried to find it in here and I couldn't find it. Can you tell me about the neighbors?
Sure.
Are they residents?
So if we go back to the map. Okay, so the closest dwelling is going to be just south on the parcel 45A12C, and that's where the residences start on Blenheim Road, and they go south. There is one house directly across Blenheim Road. I believe it's 100 or 102 Anderson Highway, so there's one residence there.
Is it occupied?
Yes, sir. Yes, sir, that is occupied. I believe the Randolph family owns that land there. And to my knowledge, I don't think there's any additional residences on 60 heading east, but there would be heading west. And then, of course, Pineborough Road would be not too far west of where this proposed location is.
Excuse me, I'm getting out my magnifying glass.
It's okay.
I've got a question. Roger.
Yes, sir.
When they strike out something like Boston Barn or whatever,
Mm-hmm.
they say they wouldn't have an auction barn.
They're saying that they're proffering restricted uses, so while we are allowing for the rezoning of the property, if the rezoning is approved with the proffered restrictions, then those uses would not be allowed on that property, even though it is zoned B1 business. So all the other uses that are included by right would be permitted to move forward if, for whatever reason, Dollar General was not there later on down the road.
That's what I was asking. So this would go with the land, but
Correct.
the conditional use would go away if they went away, right?
Yes, so yes, the conditional use permit does go with the land per se, but it's more with the use itself. So let's say if they were to come to you this evening with a conditional use permit for this business, if that business went away, then an additional conditional use permit or rezoning would be required for a future development in that on that property.
But this would still restrict the future development?
Correct.
So why are we doing that?
I didn't ask for those, they voluntarily proffered those restrictions. I believe that they, Dollar General feel that some of those are considered nuisance uses. And so, in order to be a good neighbor to the county and a good business partner here, that they are voluntarily restricting those uses as they have been known to be considered a nuisance.
So they're saying that by rezoning it later on, it would be used for something that would be a nuisance, and then people would blame them for having rezoned.
Correct. I'm assuming, they can clarify.
You know,
What's across the street, that red?
So that's a B1 business zoned property. It was rezoned in the 2010s, I believe. There was a bakery that was coming to the county. So the property owner across the street came in, requested rezoning for the bakery, for the business. It was approved and the business never came to fruition. I believe that property owner took their business to another locality.
They actually went to Henrico. They
I
were
thought it
looking-
was Henrico, but I
they were
wasn't
looking
sure.
at a bakery.
Yes.
It was an Indian bakery.
Mhm.
And they were going to sublease a portion of the building for a dance studio. And the dance studio ended up in Powhatan.
We gotta do something about Henrico, they get the reservoir and bakery.
Well, I believe this is a start. Getting more industry, more businesses in the county will be beneficial to everybody here. And the fact that it's a DG market and not just a Dollar General store, I think will be helpful to the residents in that area.
Well, I can remember as Ms. Johnson and myself were discussing earlier, just across the road from it used to be a country store. Just to the west was a fairly significant country store. And just to the east was a very successful gas station. And a little farther to the west was a restaurant. All of that's gone now. The people in that area have nothing. This would, in a Dollar General market, provide some exposure to groceries and food goods in what is basically a food desert.
Are any of the other Dollar Generals here?
To your point, is it similar to the market that's here in town?
Yes, sir.
Okay.
I think she showed the market as 12,480. So the retail space is bigger, but the services they offer the same, it's just the building is smaller.
Just be a little larger, okay.
So coolers, the 12,480 has 4 coolers, this one has 3. So basically the retail space is slightly different to answer your question, but they carry the exact same product. And that was the approach.
Thank you.
This year, it's the same as what we're.
Any other comments or questions? Do I have to open a public hearing to have the applicant make a presentation if they'd like?
We can open it after they make
Okay.
the presentation. It's
Would
fine.
you like to make a presentation?
Yes, ma'am.
Okay. Thank you.
Yeah, well, good evening, Mr. Chairman, I'm Kerry Hutcherson, good evening, all members of the commission. My client is Retz & Companies, the applicant here in this case. And so Retz & Companies is under contract to purchase this property from Valco Investments. Ms. Johnson did a great job with her presentation and staff report, and a lot of what I had planned to cover, she has covered already very well. So I'll skip to just a couple of things to point out that maybe were not covered quite as much in her presentation. The first one is just piggybacking on this comment about this being a DG market product. It directly addresses what the citizens of Cumberland County during the comprehensive plan process identified as their top concern or challenge about living and working in Cumberland County. There was a poll done as part of your comprehensive plan process, I understand, and it was printed in the comprehensive plan. 83% of the respondents said that access to groceries and shopping was their #1 challenge for living and working in the county. Other top priorities that citizens identified were economic development, business attraction, helping to balance out the tax burden, providing some businesses here would definitely help with providing some balance for the residential and agricultural landowners and the tax burden they bear. Just to answer or to respond to a question about attracting other businesses, because I understand that's it's an important part. If you're gonna let a business in, you wanna make sure that it's going to provide a catalyst for the businesses. What we found typically attracts, the Dollar General or DG Market will attract other competitors, so other grocery or, food service. Also, because Dollar General offers discount household items, and a lot of it tends to be the type of product you get at a CVS or Walgreens or other pharmacy type store like that. Those typically will come in and locate after Dollar General or DG Market has come into the marketplace. The other thing we see a lot is the fuel station convenience store. None of that's here right now, so you would think that once the DG Market is in place right next to Clinton, if there's encouragement by the county for more business to come to that area, and the comp plan's recommending it, that those other uses would see this as an opportunity and come and locate there. I don't know that I have a whole lot more in the slides that Ms. Johnson hasn't already covered, except I did want to mention, yes, with the proposed site plan, Ms. Johnson had talked a bit about our request for the parking exception. With 35 spaces being required, what we're currently showing on this plan is 43, so that would be beyond what's required as a minimum by the zoning ordinance. We'd like to be able to do as few as 30 because number one, Dollar General in their market study has said this store with its anticipated peak hour need for parking will not require more than 30 spaces. And if we could reduce that parking, it'll give us a good shot at being able to turn that store so its front is oriented towards Route 60. If that's something that's important for the county. If it's more important that we provide additional parking, then we can just go with this layout, that's fine. I'd also just say as a disclaimer that we don't have full survey and engineering plans on this site yet, so allowing us for the parking exception would give us the opportunity to try to reorient the store. We can't guarantee it right now until we have full survey and have the ability to know exactly how far everything is from the road and from the creek, which brings up another point I wanted to make. We're showing a 50-foot creek buffer. You may have seen, and I'll go back to the aerial real quick just to show you in more detail. So these properties have a lot of trees on them. The residential property to the south that there were some questions about, the existing conditions have vegetated buffer along that creek with a good number of trees. I'm trying to figure out, is there a way I probably can't do this with the screen, so maybe I'll just point this out to you. Can you see where this 6, 6, 7, 8 is, that green dot? I don't know how good people's eyes are, it's really small. But that's approximately where the existing house is, I believe. So there's a good amount of forested area on that owner's property. And of course, that owner's in control of keeping as many trees as that owner wants for a buffer. And then of course, we'll be providing the creek buffer. And so that'll provide some more screening between our use and that residential use. So I know there were some questions about that. I think what we've got planned here will make sure that the commercial aspect of this property, if it's rezoned, won't be impacting the residential area to the south. Other than giving the person a place to shop for groceries, which is a great benefit, I would say. So I think that might be it in terms of what I had planned to cover that was not covered by Ms. Johnson. Oh, this reminds me of the proffer conditions. So there were questions about these restrictions on uses. This is something that we certainly could withdraw if the commission and board would prefer. We find that sometimes when we're rezoning for Dollar General, people will ask, well, what happens if the Dollar General goes away one day? And in many localities where we rezone for just a business general district, there will be members of the public who are worried that if that property was rezoned for just the blanket B1 district, that there might be some uses that would be allowed by right there that wouldn't be favored by the neighbors. And so we've had a few experiences with this, and we're used to the types of uses that most people don't want next door to them. So that's why we just defaulted to this list of uses to prohibit. If there's anything that you think you might want to keep, and the county is supportive of it, we're fine with amending the application so those uses would not be prohibited. But that's the explanation for why we just voluntarily offered to prohibit these uses. And in terms of looking at the future, another question you might have had is, how long could the Dollar General market be there? And to explain a little bit about the business relationship, Retz & Companies is a preferred developer for Dollar General. They get a list of areas from Dollar General where, according to Dollar General's market research, they've identified there's demand for our use here, and they circle an area on a map and they say, go find some land that you can purchase, zone it if you need to rezone it, and then build the store there. And then if all that is done, the store is built, there will be a lease with Dollar General. And if you extended it out with all the extensions that could be exercised, it could be 30 years max. Or Dollar General and the landowner could come to an agreement to extend beyond there, but that's what the standard lease is written as. So that gives you an idea of the longevity of these products. They're expected to be, if things are going really well, they're expected to be a full 30 years. But then something could happen after that. So that's kind of the thought is, let's not let this zoning open the door to every use that could be permitted here, because typically people don't want some of these types of uses in areas where there are some residences.
I have a question. What are the Dollar General's hours of operation?
Oh, Greg, you might have to help me on this. Is it 9 to 6?
No, it's 8 a.m. to 10 p.m.
8 a.m. to what?
10 p.m.
Okay, thank you.
Yes, sir.
This is Greg Stewart. I'm sorry, I meant to introduce him. Greg Stewart from Retz & Companies.
And I'm happy to, once he's done, answer some general questions just about the design and make sure, answer any questions about the overall layout as well. So I'll just let him get through the application and legal aspects.
And I'm through it, really, so if you want to come up here and just field questions with me, that's fine.
If you don't mind going back to the site plan, technology, tobacco farm, it's to Carrie's point, right now, I guess let me back up a touch. So speaking to the parking reduction, and that doesn't look a lot here. So the reason we came up with 30 spots is because 30 spots are equated to that section there. So on the left, which would be facing the front of the building, right? So if the planning commission and board of supervisors were willing to waiver the parking requirements, we could remove those entire row of parks that are on that residential side of the property. What that allows us to do is a lot of flexibility. Now, to answer your question about the entrance directly, this is what I'm sorry.
No, since there's nobody in the public, I'm gonna move so we can all see what you're pointing
Makes a
at.
lot more sense.
Sorry.
So Dollar General has 6 prototypes, and they're based on the entrances and where the entrances are. 2 of the prototypes are smaller for the front facade with the longer sides. 2 of them are larger front facades with a smaller depth, and the other 2 are what they refer to as corner entries, which the entry is not centered into the middle of the facade, it's on the corner. So with this one right here, when the idea came up about the front store facing, I know without a shadow of a doubt, I can make a corner entry work. Okay, so what that would be is instead of the entrance being here, the entrance would be there on the corner facing more of the intersection, which is my understanding what the idea and goal is. But if we can get rid of these 30 parks, that opens up a lot more flexibility to actually have the entire front facade facing Route 60, to where it's the other prototype. Now, I can't guarantee you that that's gonna happen, because with this site, if you'll notice, as we're private utilities, so we're gonna have to get a well in there. Where that well, where there's waters, we don't get to decide that. Generally, we have the well proposed, as you can see, up Route 60. But if water's not there, we might have to move it around. Same with septic. We put the septic on the high spot because we think that's where, in our experience, that's where septic will occur. And then lastly, you see our stormwater management facility here, where we're gonna have to treat stormwater. All three of those variables, if it lays out perfectly, I can say with about 85 to 90% of certainty that I could probably make, and if the survey comes back with what we expect the parcel to look like and there are no surprises, then we could probably get the front wide facade facing Route 60. But I can't guarantee that. So I wanted to be open and transparent about, I know that I can face the entrance more directly towards that intersection, whether with the parking reduction. I know that I can do that 100%. But the prototype, this would be the front of the store, and we would manipulate the site plan to where the entrance would come in and then parking would be in the front and the store would be facing that way. I can't guarantee until I get survey back, my well testing back, septic testing back, and figure out the infiltration rates. So I just want to be transparent about what we are trying to achieve, but not also oversell it, and it's a guarantee that I can do that. If that answers the questions about the purpose for the waiver and parking request. Other than that, Carrie did a great job, and Ms. Johnson did a great job about the natural buffers. That's a creek bed there with 50-foot buffer. We can't touch those trees even if we wanted to. There are also UDO requirements for buffering and screening that we're going to have to apply to based on Cumberland County's code. I'm happy, as far as the entrance, Ms. Johnson accurately stated, if it were up to us, we would prefer our entrance off Route 60. It's an heavily trafficked area, that would be beneficial for our client, but VDOT says that can't happen. VDOT code makes it be 225 feet from that intersection. So once they said we couldn't have it here, we said, well, we have, if you notice, we have just a touch over 225 feet. So we said, VDOT, our site doesn't really lay out for your rules. Can we have an entrance here? And they said, no, sir, you push that entrance as far away as possible. So that's not really, we don't prefer the entrance there. To Ms. Johnson's point, it makes our truck routes very difficult. And essentially, where that loading area is and that truck route, if you know anything about truck routes, it's going to have to come in here. It's going to have to back up to load and deliver there. That's also going to play into a factor of if we can make that other prototype work. But our entrance here is driven by VDOT. And if they would let us enter off Route 60, I could give you whatever prototype you wanted and whatever facing building you wanted. But the fact of the matter is VDOT won't allow that because of their concerns with people entering in off the higher travel 55 speed limit, where this is a 35 mile per hour speed limit. So to answer I wanted to be clear that there are a lot of site constraints here that will not allow us to guarantee that it's going to be rotated that way. But Dollar General wants that. It sounds like the county wants that. We want that. If we can make that happen, we will absolutely make that happen.
Do you have proposed for signage? Do you have a monument style like we have down here, a pedestal style where it will be raised?
You can correct me if I'm wrong. UDO, currently we have planned for a pylon sign because it's Route 60. That's what the UDO calls for. I believe the square footage is based on either a road front lot.
Right.
So we currently have a pylon sign proposed. That's what our client would prefer, but we obviously do not want to kill the deal over how high the sign.
Of course, all lighting will comply with the county code as far as not having lighting
Light
pollution.
Yes, sir. Dollar General usually places the light here, and the current light in this plan is one light, and it's right there facing the store. Every fixture they use is dark sky compliant, and we actually have to, not just for the county, we actually have to submit a photometric analysis to our Dollar General, our client, showing that no light pollution exists because they have had it in the past where they've actually been sued for it. So that's a step that not only have to take for the county's ordinance, but also for our client. Yes, sir.
Have you spoken to the neighbor in the south?
So, interesting, Mr. Eldridge is the property owner for Valco Investments. He owns this property. I actually called him this morning, this afternoon when I was on my way, and he was cutting the grass, keeping the property up, and I asked him to go down and speak to the neighbor to the south. He did not, it was not able to get up with him. I don't have any communication with him now other than the paperwork that we've submitted, the notice that was sent out. I don't know if he is for or against it, the use of it, but I am intending on getting at least having contact with him, because there will be some things that we need to make sure that he's aware of if we do move forward with development. Wait, if we put that entrance there.
So it's essentially the same operation right down the road here as this operation. It's the same operation right here across from the Shell station. The Dollar General Market is the same operation.
Store smaller, square footage of the store smaller, but yes, and I don't know what prototype, if you can pull up a picture of it, I didn't
It's
know.
a straight on white.
It's the wide that you can see, the wide part of the building faces the
So you
street.
don't own that market?
We build it, I just get off the top of my head, tell you what every prototype was put there, so, if it's a CD, then yes, this is a slightly different product, because the CD is the wider one.
Who manages?
Who manages the store? The existing owner.
And who is that?
So we get the lease in place, and a lot of times we will then market this to sell, someone buys the lease from us. I don't know who owns that current.
That makes sense, why I left the ball field on Saturday afternoon, and my wife said, take me to the nice Dollar General up here on 13th, on 45. Makes sense. We drive right by this one,
To go down.
go home, to stop there, to stop at the market. Not bad.
Do y'all have any other questions?
Thank you very much.
Sure.
All right, we'll open the public hearing. And I don't believe there's anybody to speak. We'll try to check.
I don't think there's anyone here to speak.
Okay, I'll close the public hearing. And any commissioner comments, questions?
Mr. Chairman, I move the adoption and forwarding to the Board of Supervisors of the approval of RUC 25-01 for Valco Investments with the proffers being extended. And also I'd like to include in the motion reduction of the parking requirements so the front of the store will face Route 60.
Second?
Matt Seal,
No.
Steve Donahue,
Yes.
Kevin Meadows,
No.
Hubert Allen,
Yes.
Steve Rosen,
Yes.
Harry Donahue,
Yes.
William Flippen.
Yes.
Thank you very much. Thank you, guys.
Move on to old business.
Thank you. So, first item for old business, again, I keep this on the agenda, but I don't have any updates currently, is for potential code amendments, other than, of course, the Board of Zoning Appeals amendment that we had for the public hearing for tonight. The next one is the Cobbs Creek Reservoir update on pages 43 through 45. I do have the following images. These were taken by drone photo by an employee of Henrico County when the pump station stopped pumping water from the James. So these pictures were taken on May 6th of this year. And here is the one privately owned privately owned residence on the property. And then here's kind of a wide range shot of the entire reservoir. And some of you have probably already seen this video. However, I was able to include the link here for
facility is built, facility is operating, it is fully full.
It's amazing. It's, you know, there's been construction at this site for over right at 10 years now, and this, getting that 345 is the culmination of 10 years of hard work and effort out here. It's amazing. We've gone from the wooded site, moved 3.5 million cubic yards of earth, built the 3 dams, put the intake structure in the river, and built the pump station, and the admin building, and this tower. It's been an incredible project.
I think the challenge is like we put those numbers out there, like 1,100 acres, 15 billion gallons. You have people who were like very, very closely involved in it, who still can't wrap their head around like how massive this thing is.
Coming from the site where it was nothing but trees to now looking at roughly 1,100 acres of water, it is something I never could imagine this was what it would look like. We saw the renditions, the digital images, and they say that's what it looks like. You don't believe it until you look over your shoulder, you see Cobb's Creek.
For everyone who was involved, just being a part of something that is like so big and is so impactful to not only our community but the entire region. It's just amazing to think that this was an idea not too long ago, and that that we all kind of collectively dreamt up together and worked with all of our partners to develop and design and permit, and then finally construct. And here we are, like at the top level.
Our goal is just to make sure the county is proud of what they've invested in, and it's beautiful. You know, we've come this far. From the first day we started pumping, it was a great honor, and to see that, you know, this is coming to light, you know, and now that we are here, you know, a couple of months in, it's pretty much, it's a happy day for all of us.
It was a legacy moment for my career, and something that I don't believe I would have another opportunity to do.
This is a testament to what can be achieved when people work together for one common cause, and it's actually an engineering feat to, you know, to see this kind of project go forward. And it's a testament to the leadership up in Raccoon County and the forward thinking.
That's what I have for you for the reservoir. Any questions?
Yeah.
Yes.
Who is responsible, people that are voting out there?
Who's responsible
If
for
there's an
that?
accident or something like that?
So the Department of Wildlife Resources will be patrolling for any violations for, in regards to fishing or that sort of thing. With it being in Cumberland County, we would be the first responders to that location.
Second, every place that we walked around, they had guardrails outside of the boat ramp. There was no guardrails on that ramp. I think that's kind of important, especially if people get up there and they're out there having a good time and had a couple of beers or something like that. They could easily fall in. This is not, it's not stationary, it's just.
It's floating, yes. So I will say that, and I believe Mr. Allen and I were discussing this earlier, that DWR, the Department of Wildlife Resources, in consultation with Henrico County, actually provided for the engineering of that boat ramp. So I would assume that it is built to whatever standards and codes that are required for boat ramps. I can inquire with DWR about.
I think it should have at least one rail on one side or something.
Well, one thing too, I noticed that they've got tie-ups for boats on both sides, so that precludes having a rail of any sort on the floating dock. You've got the hooks for your ropes to tie the boats up. And I think it was something like maybe 15 pockets, ports at on each side of that floating dock. So if you put, with that there, you can't really have a right one of any sort.
They don't allow, no gas motors I'm aware of, correct?
That is correct.
So, it does not restrict gas motors, it just says it can't be more than 10 horsepower.
10 horsepower.
Yeah, less than 10.
So basically like Broward. So the restriction or whatever is on that's on DWR. It's not on the county. We have nothing to do with it. I mean, the video clearly states, they think it might go for what they did, we didn't do squat, so, you know, that's,
That was, they were saying,
blame him right there.
I'm sure it's
Blame
built
him
to
right
cover.
there.
I'm sorry,
I'm sure it's built to cover.
I'm sure it is.
Yeah.
but if it's a floating deck next to the ramp, and you start tying the boats up, on that side, you're gonna be interfering with the ramp. So it seems like they should be able to put a railing on one side of that. Even,
I can ask about it.
We don't control that.
Yeah, we don't,
It's-
so I don't
that's
know.
DWR. It's theirs now, it's the state's.
I don't know what would come of that, but I can definitely look into that for you guys and see what the requirements are for that. I just don't know, but I can look into that for you. Okay?
Thank you.
Yes, sir. Okay. Up next on your agenda for old business, I had an update on the solar projects in the county. So the county has approved 10, I believe, solar projects. I just wanted to kind of give you the map overview and where we are in construction currently, with each of the projects. So starting in the northern end of the county, we do have 4 that were approved. Conditional use permit 2105 for Cox Family Solar. That is a smaller scale solar project off of Amptill Road. And then we have the Cumberland Solar and Boston Hill Solar projects, which were from SunTribe. We are awaiting final site plan on the majority of these, so they are past the process, or past the point in the process where they've obtained local authority to go forward with these. Now they're in the stage of construction or in the development where they're applying to the PJM for their state permits, for Dominion to get the projects approved through not just DEQ, but through the state as well. The last one you see here on the far northeast is the Hecate Solar. That was the most recent one that we did in 2023. Here in the middle portion of the county, we had 2 projects that were approved in 2023. They were Jamerson Solar 1 and Jamerson Solar 2. Jamerson 1 was on Route 60 just west of Oak Hill Road, and then Jamerson Solar 2 was actually on Vogel Road. Both of those applications have actually been withdrawn. The developer reached out to us, I think it was very end of December or very early part of January, saying that they were not going to go forward with this. And the reason that they gave was Dominion is requiring installation of fiber along these lines, and that was not included in their budget. So they did not have the money to install the fiber that is now being required of them for these projects. So those 2, while they have been approved, they will not be going to construction.
The Board of Supervisors had some discussion about limits or percentage of land. What happened to that discussion?
So we have, the board has adopted a solar policy in addition to the ordinance, which would give further guidance on how solar is developed in the county. And I do believe that's on the website, but I can check on that. If you'd like, I could send that to you guys as well.
I can look that up. I didn't know if we could get a percentage or talked about it and
I don't think they went with a percentage of the locality, the land in the county to be used for solar. Moving down to the southern end of the county, we do have 4 projects, 4 conditional use permits, and 3 projects. Conditional use permit 2102 for the Dunn property, which is on the west side of Route 45, Cumberland Road, just past church on the left-hand side, help me, New Life? Yes, thank you, New Life Church. The next one was CP 2103, which was Rowlett Site 1, and later on in 2022, they came back and asked for, they wanted to revise the original conditional use permit, but because we don't allow revisions, they had to go through the whole CUP process again for Site 2 on that same parcel. So they have Rowlett Site 1 and Site 2, which is located at 1650 Cumberland Road, and then the Dunn project, which is 1671 Cumberland Road. Those 3 are actually under construction. They are in the land disturbing part of the project now. Rowlett Site 1, which is the first section of the property that you get to, that was previously approved. That site is, I believe, to elevation, so they are just working on the DEQ requirements, land disturbing requirements for the stormwater structures that are on the property. They did have a little bit of what they call a dirt issue. One site had too much dirt and the other site needed dirt. So we're trying to find a way to have that, without having to redesign the entire project for both locations, how to make that work without having dump trucks constantly going up 45 for that quarter of a mile, transferring dirt from one property to another. So they are still working on that. The last one you see in the far southern portion of the county on the map there is CUP 2304. That is the Plank Road solar permit that was approved. That one, again, has been through the locality, gotten their local governing approval, and they are now in the state line, I guess, waiting for PJM permits and DEQ and things like that.
Can I ask a real quick question?
Sure.
Sorry to interrupt, that's why I was trying to flag you. The Rowlett and Dunn, are they finished their litigation or filing or whatever between the developer and the owner? Because I noticed that was put at a standstill. We were never updated. They were working out some payment issues. And every time I've ridden by, you may see one vehicle going in and out of that. So, I mean, is there something?
The issue was not with the property owner and the developer, it was with the project owner or the developer and a subcontractor.
Making payments, so that's been taken care of?
To my knowledge, I
Okay.
have not heard anything different, so the only reason it was brought to my attention was the subcontractor was reaching out to me to see if there was a way for me to force them to pay their sub, based on the conditions of the CUP, which there was not. Again, I haven't heard any updates. I'm assuming that that has been taken care of. I can get an update for you from the developer. Again, since I haven't heard from the subcontractor, I'm assuming that all has been taken care of, but I can.
I've had several people in District 5 that live around there said they haven't seen anything in a couple of months going on up there.
I can guarantee you
And they
there's
moved.
construction
Okay.
going
They
on
said other than
both
seeing
sides.
vehicles going in and out, but
Yeah.
all the construction equipment gone, so.
No, it's not gone.
It's not
So,
where it was, so I.
correct,
know that.
it is. It's moved over to the other site because again, they're looking at how to manage this dirt problem where they have an excess at 1650 and then they have a deficit at 1671. So that's why you may not see the trailer that was there, just had hay in it, was hay storage for sedimentation measures. And then they had a buggy there. So all of that equipment is just moved over to the other site, which neither one of these developments can you see from the road. So they are being actively worked on.
And the only reason I ask is because the county administrator was gonna look into it, and I haven't heard any more back, so I just wanna make sure that, like other things, I know some of the solar projects have actually downsized to the scale of the project, correct?
They generally do that. Once they come to the county, they'll come with their plan, what they want to do. And then once they go through the state permitting, through DEQ with stormwater and everything else, they will generally get smaller. Because what they come to us for approval is for, you know, what they want, but that may not always be what they can get. So yes, that does happen often.
Thank you.
Any other questions about solar? Okay, so next item on the agenda I have is just a joint, an update or follow-up regarding the joint workshop that the Planning Commission had with the board last week. A few of the issues that were brought up or questions that were discussed were road maintenance agreements. Currently, that is not required for family subdivisions. It is exempted in our code. It was discussed that that could possibly be included going forward, that shared access agreements and road maintenance agreements would be required for family subdivisions. And again, that is permitted. That could be a way to move forward if the Planning Commission board wishes to do so, but that would require a code amendment. The Private Road Access Design and Standards Manual, the document was created in the late 2000s and was last updated in 2011. However, at some point, the manual was referenced in our ordinance as a guiding document, so staff is recommending that that be removed from the ordinance and enacted as policy, and of course, updated since the last time it was done so was in 2011. Duplexes with wooden stairs were also an item that was discussed. Some concerns were raised regarding the above-below duplexes utilizing the wood stairs. One suggestion was brought up to require the installation of metal stairs. Again, staff has done additional research with the building code and found that section 102.1 of the Virginia Residential Code states that buildings and structures should be permitted to be constructed at the least possible cost consistent with the recognized standards. So because our building department ordinance, our ordinance for building inspections, doesn't specify anything otherwise, we've adopted the Virginia Residential Code and the International Building Code, the IBC. So that's what we have to go on. For camping on private property, there was another concern regarding the use of campers and RVs as permanent residences or dwelling units. Staff did provide that RVs and campers are not built to the residential code and therefore are not permitted as dwellings. They cannot also be connected to well, septic, or electricity when a property owner wants to camp on their property. There was also a question raised about how many consecutive days determine the difference between camping and then living as a residence. I believe one of the board members, I could be wrong, I didn't write it down at the time, but somebody had mentioned that there was a section in the state code that referenced that number of consecutive days. I've looked at both the administrative code and the Code of Virginia, and I was not able to find anything regarding that. However, our zoning code does provide for a definition of a campground, which does stipulate that the occupancy is for less than 30 days. And also, I think you had brought up the number of campers or camping units, where if it was less than 3, it did not constitute a campground, but our definition of the campground does say there's one or more. So it may have at one time said that maybe more than 3 constituted a campground, but the current zoning definition does say that it's one or more.
Can I make a comment on that? Based on the idea of there's so many days you can stay in one place as a residence. So
I'm sorry?
You can stay in one place as a resident, it's like a motel.
Right.
So working in Prince Edward County for the Department of Social Services, we run into this all the time. There is somebody that stays in a motel, who is homeless, so to say. They can stay 29 days. Or 30 days in that month. If it's 31 days a month, they can stay 30. 30, they stay 29. But they have to check out, go somewhere else for a day to come back to resume that. So that's somewhere where that law is coming into place. Whether they're talking about a camper or whatever it may be, it is state code, because they are literally kicking them out, saying you gotta go somewhere before that. Or 12 hours,
Right.
you know, whatever meets their standard. So it is legit. It happens all the time, we see it all the time, because we collect the victims.
Right.
That's it, yeah.
I'm sure there is probably
And I don't know where it's
something
at.
there. Yeah, I wasn't able
I will
to
find it
find
for you.
it regard, I appreciate that, because I wasn't able to find it for any regulation regarding camping, campgrounds, that sort of thing, so.
But it's
yeah.
all the same, it's all related, I can promise you, because it's happened at campgrounds, it's happened at, they all say you have to move.
Right.
Even if, like in a campground, you have to move a site. Just move your trailer. One of you.
Well, you have places like Bethpage and all that are permanent campers, permanent mobile homes, or campers that are in a permanent location, and they don't, I'm sure it has something to do with ordinances maybe, because their Bethpage is all over, but the one down on the bay. I mean, they're nothing but trailer, mobile home campers with wooden decks on them, and they're year round. So.
But if they're permitted as a campground, they're good to go. But like the ones that are not, or this little house, little bitty thing here, it's the same, it falls in the same code. We've had the county call us and say, hey, in Prince Edward County, say they gotta move, they gotta go. They crank it up and motor on over wherever, and they're free and clear. And they come right back.
So these campgrounds that we've had, people working in Cotton Creek for, 6 months at a time or whatever, are they supposed to be living under that 30 days?
So they permitted as a campground. So as long as they're permitted as an RV park or an RV campground or any sort of campground from the zoning perspective, then yes, they would have to, I guess, like.
They're good to
You
go.
were saying.
As a campground or whatever, you're good to go. They can stay as long as they want because they're paying a lot rent. They're paying a fee for the lot. They're not paying anything else, so they're paying a lot rent. It's just like you live in a trailer park, you buy a trailer, hey, I'm putting you. I'm in the trailer, I'm paying you lot rent. Trailer will live. You live there for 10 days or 10 years, you're good to go. So it's a campground, that's what they're doing.
So a campground, they can stay as long as they want.
Yeah, yeah.
But you just said a minute ago that they had to move one lot down.
No,
It wasn't a campground.
It wasn't a campground. I said in certain instances where they say their policy says you have to move, you have to move. But it's in certain, like I said, a lot of things the hotels say, oh yeah, you only got 30 days. Or here, you got 30 days, but they're a temporary residence. And that's what they qualify as. Where a campground is, they fall in both categories because they can be temporary or they can be long-term. From what I've seen, from what I've seen and what I've read.
Right.
Definition of campground, which stipulates the occupancy is less than 30 days.
Right, that's our ordinance, yes.
So in our ordinance,
Yes.
they're a campground. They're
Mhm.
supposed to not stay there more than 30 days.
Correct.
Check it out.
So, you have a campground, if you designate a portion of your property as a campground, you get it permitted. Can you, we still wouldn't be able to do it for longer than 30 days. I was gonna say, can you live in a camper trailer then, and hook up to the water?
You can camp at a campground that is permitted by conditional use permit with a camper or an RV that connects to the well, not even a well, but I guess they would have water, and they have a place where you could dump your waste, but it wouldn't be a permanent connection to well and septic.
I guess the key to permanent would be, because I'm not connected. And I guess that would be your.
So what I have come across, where there are people who are living in campers as dwellings, is they literally have a connection from the camper itself to the drain field, to the pump, to the tank. And then they have the well, they have the camper connected to the well, and then they have a temporary electric service where they've connected it, into the camper. That way.
Travis did justice.
It's not permanent, it's not built to stand as a dwelling. It's not a permanent.
But it's, the connection's not permanent. They're free and clear.
No, it's not permitted as a dwelling, so we wouldn't allow them to live in it as a dwelling.
It's been happening for years.
That's right, and we haven't had the staff then to enforce it, so just like we don't have the staff now to
We don't
enforce
have
it.
it now to.
Yep, you're
It's
right.
still out.
Which means it's silly law. If you can enforce it, there's no sense in having it.
But they could beat it any way they went to court, they could beat it and say it's a temporary connection. Because all they
It's
got
not
to
silly
do
law, because if you don't have it on the books, then the county's almost ratifying the action, whether it was appropriate or
They're
inappropriate.
ratifying the action by not enforcing it.
No, they're
But I
not.
mean,
A law that is not enforced is not a law.
Alcohol, man,
So every
right
time you go
now.
down the road and go 1 mile an hour over the speed limit, and you've broken the Virginia traffic code.
If you went
because the
to,
law's not enforced.
you might get a ticket, but if you went to, like,
It's
go
just
down
not
to Boone
enforced. It's not
Tyson's
enforced.
right now.
What is the law when you drive
So
down?
you just can't, you know.
55 mile an hour zone.
That said, you're in a permanent connection. All you do is that, no, it's not permanent. You
Not hard water,
I mean, that's one of the ones I know. I know there's some others. These, they're not making, it's not a racket. I mean, they were working on the Cobb Street. They were working on pipeline, wherever.
I mean, I know of a guy personally, I'm not gonna tell you who he is or where he is. He's hooked up to his well with a hydrant and a hose that runs to his RV. He's hooked up to his well.
But it's not permanent.
Now, it's, according to her,
It
it's illegal.
doesn't matter, it's not permitted as a dwelling. Now,
Right.
somebody can camp on their property.
Well, he's been there for longer than 30 days, for sure.
Well, then that's illegal.
Right, that's what I'm
Yeah.
saying. But, I know 3 individuals that are in similar boats, but I'm not gonna say who they are or where they are.
Okay. So going forward, after we have those items for discussion, there was areas of focus and a work plan that was discussed. Of course, some of these will require additional funding, as again, this is a one-person department. We are looking for a small area plan for the Randolph and the courthouse village. I did speak with, or Derek messaged me earlier this evening and said that he believes he may have found some grant funding for that, so I'm very excited. Mixed use code language. This is something that I have wanted to, it's been a goal of mine for the past 2 years, is to provide a draft for mixed use in the zoning districts, especially here in the courthouse village. I feel like that would benefit everybody here to allow for both residential and some commercial or business uses going forward. I just, again, putting out fires doesn't lend to getting off, checking your items off of your dream list here. Review of minimum lot sizes for agricultural and residential zoning classifications. It was discussed that the intent, I believe, is to increase the lot size in agricultural zoning districts and then review in further detail the minimum lot sizes for the residential zoning. I believe Derek had mentioned, Mr. Stamey had mentioned Crawford's and capital impact model evaluation. Code amendments for shared access and road maintenance agreements changes, requiring that all subdivisions comply, which would include those family subdivisions. Revise and redevelop the private road access and design standards manual. And then, of course, potential additional research on the issues regarding camping and duplex access. And that is all I had for you for old business this evening.
Can I make one of the issues discussed before with the duplex thing? It's going back and looking at this section 102.1 Virginia Residential Code referencing recognized standards. Then that goes into the National Fire Protection Association. It's referenced after that language there. And then in the National Fire Protection Association, 36-99, looking up from referencing that out of the code, it says that stairs serving as exits must be enclosed and illuminated. And then there's other language in there about what they have to have, whether they're access stairs, single exit stairs, and this is above below again. Duplexes.
Can you, I'm sorry, was that 36-99?
36-99, and then that has like A, B, C, D, E, F, G. So it's paragraph B.
Okay.
That's where it has the language about stairs serving as exits, and they have to be enclosed and illuminated. And then it's also when it's referencing the cost being least amount of cost possible, consistent with recognized standards. It also references like the maintenance of the repairs to them.
Yes.
So I understand the language of it not wanting to be restrictive as far as cost during construction, but then if you look at, again, a lot of duplexes above, below, not really being, going forward towards the home ownership. I mean, it's coming from about the top part of the duplex or the bottom part of the duplex. It's most likely to be a rental, so the cost is going to be incurred by not the person, the resident that's living there should be maintained by the person that's owning the property or operating it as a business. So would it not be more beneficial to them running that duplex as a rental property business to have a staircase that was, even if it didn't come up before and I didn't think of it, but even if it were to just be enclosed, it would be safer to the resident and to anybody that's going in and out of it. Because then you don't have to worry about it being wet or covered in ice or covered in anything else, and then it being marked as the exit and entrance. I mean, most of them here now, they don't even have like what address, you know, if it's 96 and 98, which one's above, which one's below, you don't even know. So there was more in there where the code is then referencing these other materials like the National Fire Protection Association stuff, which I can see where ones that have already been built, they've already been built and they work by, right, you know, appropriate at the time, but I think there's room for improvement there without being restricted too much to the owner operator or the, you know, negative benefit of the person that's living in it.
Well, I think the building official, myself, and the county administrator are going to look into both of those topics further, so we can report back later on.
It was too much to read all at once because it was code referencing other codes, and then it's all recommended standards. So I think it's subjective or case by case maybe, depending on the design and layout of it all. And it seemed like there was a lot of delineations between whether it was a single entrance, single exit, or stuff like that. Like it became very specific to that one thing instead of being like maybe a code, maybe more of a case by case thing, or property by property thing.
New business?
Yes, sir. First item for new business is a major subdivision survey, or major subdivision plat preliminary that's coming to you guys for approval. This can be found on pages 50 through 56 of your packet. And here you'll see the survey, the preliminary plat for the subdivision. It proposes 7 new lots ranging from 2 acres to 21.29 acres. They're all zoned A2 agricultural, and FEDA and the Health Department have reviewed and provided endorsement of the survey as presented.
I know the applicants well. Does that make me have to be accused or whatever?
I don't believe if you don't have any potential gain, then you should not have to recuse yourself. Is there any questions about this major subdivision?
motion on this?
Yes, sir, I do need a motion.
Mr. Chairman, I move that we approve subdivision 24-53 and submit to the Board of Supervisors with the recommendation of approval. Does not need to go to the board.
No, sir. The planning commission has the authority to approve the preliminary plan for the major subdivisions. Once that is done, then I'll reach back out to the applicant and they can provide the final
I'll
plan.
amend my motion to strike the board.
Second.
Mr. Matt Seal?
Yes.
Mr. Steve Donahue?
Yes.
Mr. Kevin Meadows?
Yes.
Mr. Hubert Allen?
Yes.
Mr. Steve Rosen?
Yes.
Mr. Harry Donahue?
Yes.
Mr. William Flippin?
Yes.
Next on the new business agenda item is a Board of Supervisors update from Mr. Stimson.
I really don't have anything to report. The only thing I do want to add is something that Mr. Steele said. Anytime, especially when you get into duplexes and whatever, building codes and stairwells and stuff like that, if any of y'all have concerns, in other words, hey, I like this, but I do want to add something to it, enclosed stairwells, metal stairwells, please make sure you, and I'll be at the meetings most of the time, but if I'm not, please make sure you address that to where it comes up to the board as one of those, we agree with this, but we'd like to see this. Because when it goes, and you can correct me if I'm wrong, but I mean, codes we can change, correct?
Yes,
We
sir.
can enforce, we can put our likes or dislikes or concerns to it. But I want to make sure, and I've said this several times, you know, I want to make sure that everybody's input is accounted for. Okay, because everybody offers a different perspective, and sometimes that perspective may only be in your eyes, but it can add credibility and reason why we do something, okay? And that's from me, and that's what I've told the other guys on the board. We're not going to all sit here and agree, but like I said, there's certain things that come up help our train of thought a little bit better. And again, it's just what I'd like to see and what I'd like to pass on to the rest of the guys. Like I said, with your concern about safety, and I think that's something, I mean, there's a lot more to it than just metal stairwells and safety and fire excavation, evacuation, and stuff like that. But we need to be, you know, completely upfront with what our likes and dislikes. Kind of like going back to Cobb's Creek. One of the questions was about who controls Cobb's Creek. Cobb's Creek is controlled by Russell County, correct?
They own the property,
They
yes.
own the property. They spent, what, $280 million to develop the property? Cumberland County didn't have it. There's a lot of things that would have been nice probably back when the process was happening. Fire rescue, boat rescue, DWR. I've been asking that question all along. When you have dive teams and all, we don't have those type of things here, correct? I mean, the closest dive team you may have is Goochland, water rescue, or whatever. Those are things that probably should have been involved in the process a long time ago. We think about it now. So again, who's going to incur the responsibility for that? Hopefully somebody from Game and Inland Fisheries or, you know, DCR, somebody's out on the water if you ever had that problem to be able to help. So again, we just want to use all of our foresight and use hindsight to make sure we make the right decisions. And again, that's from me. And again, I do tell that to other board members, you know, when these little things pop up. We just need to make good decisions and take everybody's input for what it is, and that's being positive. Thank you. Sorry. For somebody that didn't have a lot to report, I probably had a lot to say.
The next item on your agenda this evening is the Planning Department monthly report, and that can be found on pages 57 through 61 in your packet. For pending requests, of course, the Planning Commission has already heard CB 2401, and that is going to the board next month. We have conditional use permit 2402 for the Cumberland Fire EMS radio tower. That application is still not complete yet. They're still working with the Virginia State Police and their engineers to ascertain the final location and footing type that is going to be required for that radio tower. Conditional use permit 25-01 for Kenny's Place. They are getting towards the ability to be able to come to you for with a completed application. I apologize. So there was a multi-step process with that property where I think it was combined into one. So we had to kind of break it down and say, okay, here's step one, here's step two. And so now we're moving forward with that application. And that was for an event facility and restaurant that is going to, or proposed to be up Route 60 heading towards Farmville on the left-hand side where the big O Club used to be, which was a target shooting place, if you guys remember. Conditional use permit 2502 for Seventh-day Adventist Church. It was brought to my attention that over a weekend, a telecommunications tower was erected at the property of this church. When I was able to get in contact with the pastor there, they informed me that they didn't know that a conditional use permit was required. They've gotten their FCC permits and other state permits, so they assumed that that was kind of all encompassing, that they did not need anything additional in Cumberland County. So we've had a few discussions about that application, that project. They are aware that a CUP is required, and they are working to get the application packet complete to be submitted for approval of the tower that is already there. They do want to stream their services as well as potentially have a radio station, I believe, at the locality or at that property. One of the concerns that was brought up was, can we make them take it down since it is not permitted? I cannot do that. I do not have the authority to tell them they have to take it down because it was not permitted properly. So we again are working with the senior pastor there at the church and working with him to get the completed application submitted so that it can come to you guys for review.
However, before they get a CUP, it has to come down.
I'm sorry?
I said, however, if they do not receive a CUP from the board, it has to come down.
Yes, sir. Yes, sir. I'm sorry, what was your
The
question?
footings on that tower, I mean, how do you know how deep they are? I mean, you
So they're
can't go
supposed to be
like yours.
getting, they have, I was told that they have engineered drawings that were stamped. I don't know how we would inspect that at this point.
You talking about the footers for
The footers for the tower.
Or for the church one that's already up?
I'm sorry?
You mean the footers for the proposed tower or for the one that's already up at the church?
That's one and the same.
It's illegal
I
tower.
mean, the radio tower for the fire, those supposed to be useful for the church tower.
I'm sorry. So the original, the last one, CUP 2402 for Cumberland Fire and EMS radio tower, that's the one we're still waiting, working with the engineers and state police. I think one of the questions they had was what type of
That one
foundation?
hasn't started yet.
No, they have not
His
started.
question was about the
This
church.
is, correct, this is a completely separate tower that was
I
put
haven't
up.
even noticed, is it like a huge, big tower or is it like
No,
a
it's
live stream on the
it's
YouTube?
probably about 100 foot.
It's 200 feet tall.
120 feet, they said.
It's 200 feet tall.
220.
At this point now,
Yeah.
It's, 200.
I mean, you don't notice it, it's by the time the church.
It grins into the sky, it's silver, pewter gray. And it just grins right into everything.
Is there anything that got up over the weekend? I was thinking maybe it's with a.
Whoever's put up like a
It's
Monday,
like-
Tuesday, Wednesday.
I mean, if they got
Friday,
FCC and all that, I mean, I'm asking.
I'm sorry, I didn't.
I said, if they got FCC approval and whoever else, this is some type of like religious exemption that they can rely on. I'm just asking. I mean, I have no idea, I don't really make.
Not for the zoning ordinance that I'm aware of. There is no sort of religious exemption for requiring a
Just
conditional
asking.
use permit. Yeah.
I don't care if it goes up or
No.
falls down, that's what it is.
The only religious exemption as far as zoning is concerned, as far as the Commonwealth of Virginia, in state code, a religious organization, a church can go, is allowed in any zoning district.
If they're gonna preach on it.
That's not according to our code.
According to our code.
Maybe in residential and agricultural zoning districts, but I said maybe in residential and agricultural zoning districts, but not necessarily in like industrial.
Yes, I'm not sure what this is.
I'm sorry?
What a church or business district.
Right, but not in the industrial that I'm aware of. That's the only one that I can think of off the top of my head where a church or a religious structure would not be permitted by right. Or if it's even listed in our, anyway. In the general agricultural, residential, and you are correct, in the business zoning districts, they are permitted by right. The churches are. Towers are not. So they are in process of getting that application to us. Next one is the rezoning 2402 for the Cumberland Industrial Park. EDA is looking to revise the zoning from M1 to M2 to be more inclusive. And then, of course, this evening we had before you the REZ 2501 for Valco Investments. For zoning permits issued, there was 1 commercial primary, 8 residential primary, 13 residential accessory, and 2 farm structure permits issued in April. 2 subdivisions were approved. Both of them were minor subdivisions. And then we have now 54 pending subdivisions in the office. There were 4 surveys of existing lots or site plans that were approved, and there's 32 pending. And then, of course, on pages 59 through 60, you'll see the commercial E&S land disturbance permits that we have open. Cobb's Creek land disturbance permit did expire the end of April. However, they're working on getting their last, hopefully, land disturbance permit approved for that. There are still some areas that are not vegetated, where the vegetation doesn't meet state code requirements. So that's why they had to apply for another land disturbance permit. And then, of course, we have the 2 solar sites for Dunn and Rowlett down off Route 45. And on the bottom of page 60, you'll see the potential code amendments that are not changing as of yet. And you'll see the map showing the approved subdivisions on page 61. And then we have the building inspections monthly report, which is on pages 62 to 63 of your packet. For the month of April, there was a total of 100 permits issued. Total fees collected were over 14,000, and total COs issued were 4. So year to date for 2025, that makes a total of 291 permits. Total fees collected were $44,845, and 24 certificates of occupancy have been issued. And that is all I have for you this evening.
And I don't think we have any general citizens comment this evening. Any comments, questions from the commissioners?
I have a couple. First of all, if the Board of Supervisors is interested in our perspective, then my perspective would be that not being allowed to hook up to your water and electric and camp on your own property indefinitely is ridiculous. Number 2 is I'd like to go back just for a second to the zoning appeals document that we just passed. Ms. Johnson, could you tell me if someone were to get sick, they got the notice, someone were to go sick and go into the hospital 2 days before the meeting, not being able to make it to the meeting, the Board of Appeals makes a decision, they couldn't challenge that for not being able to go, correct?
Possibly, yes.
Yeah.
Now, they could also have somebody come there and represent them.
Yeah, well, I mean, if they had a
They could
stroke
also
or in the
call.
hospital, I mean, they're not thinking about that 2 days
I understand.
in advance.
Right.
So, okay. And then, I should know this, but I don't. What is the status of the landfill?
So, the Planning Commission recommended denial. The board has set that for public hearing in June.
June, okay.
Yes. June, well, I can tell you.
June 10th.
Thank you, sir. June 10th.
Any other comments, questions?
Yes, sir. You might not like this one, but based on my time, my daughter, her age, I'm gonna have to resign my position here at the planning commission. It's just something I need to do. My own hobbies, my own work, and my child come first, and I cannot make this proud. You may see me somewhere down the road, but she comes first.
Understood. And this is effective,
I will send a letter tomorrow, or email tomorrow, effective immediately.
what is the procedure to fill the position?
For filling a vacant position such as this, the Board of Supervisors would need to let people know that we're looking. And then whoever is appointed by the board will fill the unexpired term, I believe, of the planning commission member who's leaving. And then at that term expiration, then if they're reappointed, it would be for a 3-year term.
Any other comments? I'll say it. Sorry to see you go.
I appreciate it. Like I said, it's no disrespect, it's just, it's time. And my time is more valuable to my daughter than it is here, so.
Understood. May we have a motion?
Mr. Chairman, I move that we adjourn to 16 June. Or as soon as may be needed.
Second.
Sorry. I didn't know which one was that here. Matt Seal?
Yes.
Steve Donahue?
Yes.
Kevin Meadows?
Yes.
Hubert Allen?
Yes.
Steve Rosen?
Yes.
Harry Donahue?
Yes.
Wayne Flippen?
Yes.
Free service?
Thank you. I'll see you, stop by and see you.
Yeah. Just cross the You were probably.
I took the pretty pictures out of the pack to take to my
Did you-
wife.